Hello, my name is Bob Bennett, and we're standing in a civil district courtroom in Harris County, Texas. And beside me is Jeff Wagnon, who's one of the attorneys with Bob Bennett and Associates. And for the last 20 years, Jeff and I have been representing attorneys who have been charged with grievances. Some client or some other person has filed a complaint, and those attorneys have been caught up in the grievance system. And it's important to know what your rights are. It's important to know what you need to do to defend yourself, because it's a very difficult situation to be in, and you may not want to end up where we are in a civil district court.
This is what a grievance letter looks like. Basically, the OCDC has received an unsworn grievance form from a complaining witness against an attorney who sends it into the bar, and upon review, the OCDC has made a determination that they have alleged professional misconduct. Once that professional misconduct is alleged, you will receive a complaint letter. Once that letter is received, you have 30 days to file a reply.
This time that you have to file the reply is very essential, very important, and obviously it doesn't take a lot of time to do this if you know what you're doing. Now, during this time period, you need to be able to put together a presentation that will convince the Office of Chief Disciplinary Counsel that you didn't engage in professional misconduct. And at Bob Bennett and Associates, over the years, we have a system of putting together affidavits, test results, sworn statements, depositions, and a presentation on the law that has been successful in defending attorneys. You should think about that when you get that letter.
After we've prepared a response on your behalf and sent it into the OCDC is charged with making a just cause determination. What that is, a very low evidentiary standard, and that's whether a reasonable person would believe that professional misconduct has occurred. Once a just cause determination has been made, you will be notified in writing and given two options on how to handle your grievance matter. The first involves coming to a civil district courthouse in the county of your residence and litigating the matter in district court. The other option is to have your matter heard before an evidentiary panel. It's a very important decision. There are very fine nuances on rights and remedies available when you make that choice. It should not be taken lightly.
We first talked about this 30-day period in which you have to get your response in. You need to keep in mind that if you don't get a response in, that in and of itself is a grievable offense. Just forgetting to do it is a grievable offense. But there's another important time period, and after, as Jeff said, there's just cause been found, you have 20 days in which to make an election between this evidentiary panel and the civil district court. In Texas, we are the only state that allows you to have a jury trial in a courtroom like this with people sitting in seats like this to defend yourself. It's not something we recommend all the time, but it's something that you should be aware of, and you need to be able to talk to an attorney who's been there before.
Our firm has prepared a brochure, What Every Lawyer Should Know About the Grievance Process, and it's available free of charge just by contacting us. It's something that you ought to have on your desk. It's something that you ought to have an opportunity to review, preferably before a grievance is filed. It details your rights and responsibilities. When you call in to receive your free brochure, we'd also be happy to talk to you about your case.
We've talked about the differences between the evidentiary panel and the civil district court. We've talked about the importance of responding in 30 days. There are also other sources of information. For example, you can go to www.avvo.com, look up my name, Robert S. Bennett, and see what other attorneys and other clients who've been faced with the exact same problems you've been faced with have said about our representation. You can also go to our website, www.bennettlawfirm.com, and get additional information. But whatever you do, please don't go pro se. And as attorneys, we know what that means, trying to do it on your own. You need to talk to an attorney who's been down this road before and knows the nuances of the grievance process. Give us a call and let us help you.